Good afternoon, ladies and gentlemen, and welcome to the South African Bar Association's afternoon program. As you know, we host a speak on a weekly basis to deal with legal topics intended to assist our practitioners and other interested stakeholders, both locally and internationally, with training and development, which feeds into the core values that we hold as an organization. So this afternoon, we are very privileged to have the team from Conflict Dynamics in our presence, Marian Sher and Salim Nakhjavani. I hope I got that right, Salim. And the topic which they're going to share with us today is the value of mediation in South African dispute resolution, and they're going to touch on Rule 41A for us. I'll remind you at the end of the presentation where you can find the recording which they'll make available to us. Please allow me to introduce firstly Marian Sher. She's built a career in the area of conflict management and dispute resolution, focusing on mediating, training and consulting in those areas. She's applied these skills and experience in the corporate, the political and non-profit sectors. She started her working life working with the Institute for a Democratic Alternative in South Africa, and she was involved in mediating, listen to this, taxi violence and setting up local and regional peace committees in the lead up to the democratic transition in South Africa. So Marian completed an MA degree in dispute resolution in Notre Dame University in the US. She worked for the Independent Mediation Services of South Africa. And when you go to Conflict Dynamics website, her bio is astounding. Marian, welcome to the SA Bar Association's afternoon program. And just before you kick off, if I could share the just a short summary of Salim's bio. So he practices corporate and commercial law at the Johannesburg Bar. He mediates mainly in complex contractual and corporate governance disputes. And I'm hoping that, Salim, you can share with us how on earth that is possible. He's also a qualified process facilitator, or as they call it, an orchestrator with due corporate education, and he contributes regularly to their leadership programs at senior management and board levels. He brings substantial experience in cross-cultural communication, institution building, and corporate ethics to the mediation table. Marian, Salim, thank you for making yourselves available, and we are very curious to hear from you. Over to you guys.
Thanks very much indeed, Ronelle. And I'm just waiting for Marian to be able to turn on her video. While we wait for that, there you are. Wonderful. Hello.
Hello. Thank you very much, Ronelle, for the introduction. I was just wondering if Ronelle and Ahmed, if you could just allow me to share, please, because we do have a presentation we'd like to work through. And at the moment, I'm not able to share that, just given the settings.
AJ, will you activate access to our guests, please?
That's in order, Marian. You are a presenter now. Just try if you're able to work.
Thanks so much. Just while I get that up, I'm just going to ask Salim to introduce himself, just from a more mediation perspective. Ronelle's done a great job there, just to give you a sense of where we come to specifically in terms of this presentation today.
Great, thanks, Marion. So I, like many of the people in the room, am a practicing advocate, and my practice is mainly in corporate and commercial law. And last year, after watching Rule 41A start to unfold, I thought to myself, well, probably this area of law, this area of work is going to grow. Let me see what I can learn about it. And I had a chance to complete the conflict dynamics training last year in July during the lockdown. And interestingly, since then, mediation has become a core part of my practice at the bar here. So that's why I'm very happy and privileged to be able to talk to colleagues about some of the practical experiences of using Rule 41A, of mediating disputes, and of being an advocate in mediations, which is a particular role that you don't immediately think of when you think about mediation, but actually it's an increasing part, and it's going to be a growing part of all of our practices as Rule 41A takes root and is given life by judges. Marion, perhaps you want to shed a little bit more. I was fascinated about the taxi violence bit. That must have taken courage.
Well, maybe it was youth and stupidity more than courage at that stage. But yeah, I think the people who really had to, at the end of the day, those were the taxi wars in the Western Cape in the early 90s. And the organization who actually, at the end of the day, I worked with Bishop Tutu in a number of organizations to try and resolve the dispute and mediate it. But the actual mediators who succeeded at the end of the day were one of my dear colleagues, Vasu Gowden, who's at an organization called Accord. So I have to give them the credit for eventually dealing with that specific taxi dispute. And sadly, that wasn't the end of it. But it was a wonderful experience working with all of them. Yeah, just a little bit of introduction to me. I'm a director at Conflict Dynamics, and as Ronald said, I've worked in the area of conflict management and dispute resolution my whole career. Specifically at Conflict Dynamics, we train mediators, and a number of the people I think who are actually in this feed were either trained by Conflict Dynamics as mediators or by IMSA as mediators. And IMSA was kind of the, I guess, the background to many of the dispute resolution agencies that still exist in South Africa. So what we do is we train mediators, specifically commercial and civil mediators, and we have a panel of mediators who we make available to parties who approach us for independent mediators. So that's how we are involved in this area. We've obviously been very excited about Rule 41A and the opportunities that offers mediation in the South African environment. We were also extremely excited about the Quarter Next mediation process, which happened previously and which didn't really have the success that we had hoped it would have. So, we're really looking at this as a second opportunity to bring in mediation to disputes where it's appropriate, and give parties an opportunity to settle their disputes. Yeah, that's really just to set the context of why and how Salim and I got here to present to you today. And while in preparation for what we're going to be taking you through, which is really just giving you a bit of an overview of what mediation is, speaking a bit about the context of how one can mediate in this environment specifically, and then taking questions and having a conversation with you as to what can be done and how it can be done in terms of building this sector specifically. So as an introduction, what we'd like you to do is to think about these questions when while we're speaking, and please just interrupt us at any time to ask any questions or make comments. I mean, we really do want this to be a conversation. So the question that if you could just think about the matters that you're dealing with or are in your intra at the moment, and which of those potentially could be mediated. Secondly, think about what the obstacles are for you to actually mediate those. And if you could make a note of any of those and just discuss it with us as the information comes through this afternoon, that would be great. So on the slide, you'll see
Marion, if I can just check in with you on this. I'm not seeing your slide. I'm not sure if it's a connection problem on my side. I don't know if everybody else can see your slides clearly.
I have a similar difficulty, Salim. Perhaps I can ask Ahmed to assist us.
Or Marion, you may wish to stop sharing and to share again.
Okay, let's just have a look.
Well, strangely enough, I'm able to see it as well as the other guests. So I think it's just Salim and Ronel, unfortunately. I'm able to see its introductions and questions.
Yes, perfect.
Perfect.
Thank you. Thank you.
Well, as long as everybody else can see it, then I'm happy. Marion, just bear in mind, I may not see it, so I'll try to follow on my copy of the slides.
Well, I'm just going to, I'm surprised that everyone can see it because I've just taken it down.
Okay, now I'm not able to see it.
Let's see if it how's that?
Perfect.
Perfect.
Okay, fantastic, great. So the questions, just to prompt you again, what matters do you think could be referred to mediation or put into a mediation process within your inbox, within your experience specifically? And what are the obstacles preventing you from those being mediated? So if you could just have a few thoughts on that in order to be able to participate fully in the presentation. Okay, and then just to start with, I'm going to hand over to you, Salim, to just speak about why suddenly all this interest in mediation.
Right. So, it's Rule 41A caught the attention of advocates because they suddenly realized, well, here's this amendment to the rules. What strategic advantage can I secure for my client by using Rule 41A? And people didn't, I think at the beginning, just it sort of came in with a bit of a whimper, didn't it? Because no one really realized they had to apply it or it required anything of us at all until certainly in the Gauteng division, the judge president issued a practice directive and basically says, you have to comply. Actually, it was in the Northwest division first, so that you have to comply with Rule 41A. And if you don't, we'll strike your matters. And I mean, if you want to get an advocate's attention, that's what you say, right? So, it's important to realize that long before Rule 41A, mediation had been a part of our law. First of all of us have ethical obligations under the Code of Conduct of the LPC. One of the options we should be putting to our clients is, have you thought about not litigating this dispute? Actually, litigation wouldn't be in your interests here. To be honest, you don't have great prospects of success. You better find you better settle. And one way to settle is negotiate, but another way is mediate. Of course, in labor law, mediation has a long history in South Africa. And in family law as well, there's a statutory scheme of mediation that is in place. The court annexed mediation program in the magistrates' courts that Marion spoke about earlier was a pilot. There was, I suppose the polite way to describe that is lots of learning. It wasn't exactly the success that I think a lot of people in mediation practice hoped for. And we can explore that with you in the questions and answers if it's interesting to you. But so Rule 41A did trigger this renewed interest in mediation. But in terms of broader context, right, Rule 41A is not just an amendment to the rules. It's there for a purpose. It's there for a reason. And it's there because the Rules Board and judges became aware of several push factors towards mediation. One of them is that in the current economic climate, litigation is becoming increasingly unaffordable for parties, particularly for commercial parties. Legal expenses hurt commercial parties' bottom lines, and they certainly hurt private, natural, ordinary people on the street, hurts their bottom lines too. Now, another interesting sector-specific development is that the RAF, and I mean, many of us will be aware of the complexities and the challenges that have faced the RAF over a number of years, right? And the RAF decided to wholeheartedly pivot towards mediation as a way of dealing with disputes, simply because it has a spiraling litigation bill. The sheriff shows up about once a week to attach the office chairs at the RAF. So, you know, insurers as well are increasingly looking to mediation as a way of offsetting litigation costs. Finally, there's been changes on the legislative landscape. There has been for many years a mediation bill that is now pending before a committee. Progress through Parliament, like a number of very important pieces of legislation recently, has been painfully slow. So there's not much to report to you on the prospects for a Mediation Act, but it's important to realize that that bill has been in place, under development, under consultation for a very long time indeed. The second development has to do with I think this has been exacerbated by the COVID-19 pandemic. A lot of us in practice will be aware that judges have grabbed the pivot towards virtual courts as a way of using practice directives to regulate court work, the flow of cases through the courts, in a way that the rules themselves don't contemplate. And it's important to be aware of the possibility that judges may well seek to use practice directives to put meat on the bones of Rule 41. At the moment, those of you familiar with Rule 41A will know that all it really requires of your instructing attorneys is to issue a notice to the other party which is not filed on case lines. It's not filed with the registrar, simply indicating the posture of the client towards mediation. And that stays with the parties. It can only really be referred to at a cost stage. If there was an unreasonable refusal to countenance mediation, a judge can cognizably, under Rule 41A, subparagraph 9, take account of that in making an appropriate costs order at the end of application or action proceedings. But a lot of attorneys have been treating that as just a tick box exercise, right? So a Rule 41A notice just goes into their file, it gets served on the opposition, and it gets forgotten about. So it's quite likely we can anticipate that judges will become more robust in the way they use practice directives to actually force parties to meaningfully, genuinely engage with mediation. So that's a sort of an overview of the history, the landscape that we're in here. I'd like to hand back to Marion, who's going to describe to us something about the nature, the characteristics of mediation, including some characteristics that are unexpected or even uncomfortable for practicing for practitioners.
Yeah, so you know, again, looking at the list of attendees, many of you are trained mediators, so this won't be news to you, but in the interest of just all being on the same page, what mediation really is it's a facilitated negotiation. So as mediators, we assume that by the time the dispute gets to us, parties have tried to negotiate it and have failed to negotiate it, or have felt that it's too complex for them to negotiate and have therefore called in a mediator at quite an early stage of a process. But what you as the mediator are there to do effectively is to assist the parties to reach a negotiated settlement. There is a lot of, there are specific principles to the process, and those principles are extremely important, not only in setting up the mediation, but in ensuring that you as the mediator are able to get parties to progress the dispute or to settle the dispute. And the ground rules really are, first and foremost, the confidentiality of the process. It's an absolutely confidential process, and it's confidential not only in terms of your dealings with the parties jointly, but also in terms of your dealings with the parties separately. So it's almost confidentiality squared, is how I like to explain it when I'm training. And the confidentiality of the process really allows you as the mediator to work with the parties and try to see where the possibilities are for settlement. On top of that, and as part of that confidentiality principle, it's without prejudice. So if you do not reach a settlement, if you're not able to settle the matter, the parties revert to their previous rights, and whatever happened in that mediation process cannot be used in the legal process as it unfolds in future. So that's a really important principle in it, and it really allows parties to kind of relax and really investigate what their priorities are, what their interests are in terms of the conflict that they're in. So first and foremost, confidentiality and the non-prejudice of the process. The second principle of mediation is that the mediator is a neutral party to the dispute. So I'm always amazed when we start training attorneys, often attorneys or advocates say to us, oh no, I already mediate with my clients. I'm coming for the qualification, so to speak. But it's really important to understand that in order to mediate between two parties, you have to be neutral to the dispute. You have to be a third party. You have to be independent of the parties and the dispute that's on the table. So really important principle of neutrality and independence and that really at the end of the day allows you to act as a mediator. The role of the mediator is really that of a facilitator. So it's to facilitate conversation, to get the party to really think about what their dispute is all about, to share information between the parties, which is useful towards a settlement. So not all information, but only the information you get permission to share, and the information that would usefully move parties towards a settlement. So that's another principle. You're a facilitator of conversation and of building the settlement. There's a very important principle of the process being voluntary. And I know many of you will raise your eyebrows at this because there's statutory mediation in some instances, for instance, in the LRA. But then there's also in this instance, well, where is the voluntariness if judges are saying you have to go and mediate? But the process is still voluntary when you're in it. So at any point, parties can vote with their feet, so to speak, and leave the process if they feel that it's not progressing as they would want it to, or they feel compromised by the process. So very important principle of voluntariness in terms of this process.
And Marion, if I can just jump in there,
Sure.
Is that, Rule 41A's definition of mediation clearly says it's voluntary. And in the next breath, in subparagraph 3, says a judge can direct the parties to mediate. And so it's important to hold in our minds that exactly as you've pointed out, the voluntariness of participating is not the same thing as voluntariness of considering the option. A judge can properly, under the rules, direct parties to go to mediation, but they can, as you said, vote with their feet once they get there.
Absolutely. And as a mediator, you have to work really hard to keep parties in the process for as long as you think it's useful for them to be there. So that's part of your role is encouraging them to stay in the process and building confidence in the mediation process. Just to mention on exactly that on those lines, Salim, we have had a massive increase in the number of mediations requested from our panel over the last year specifically. I mean, we were delighted this time 2 years ago when the rule came into play, but really it seems as if it took a year for people to become familiar with the idea and in the last year, we've had a real increase in the number of mediators that have been requested. And I took a call last week from a party who said their case had actually been the judge. They were there to present evidence, and the judge said, no, postponing until the 15th of May to give you an opportunity to go and mediate this matter. So judges are already actually actively encouraging that mediation, which of course for us is music to the ears. But it certainly seems to be happening.
It also calls on us as practitioners to be equipped, because if a judge exercises that power under Rule 41A, naturally we want to be able to continue to represent our clients in the mediation as well. And that's a specific subset of skills, which I think you'll touch on later, right, Marion?
Absolutely, absolutely. Good. And then just finally, speaking about those principles, just taking you to the principle of a settlement agreement only being reached once it's written down. So big responsibility on you as the practitioners to draft really good settlements, but also that settlement agreement is final and binding. Okay, so important principle of the process. Once you sign on the dotted line, so to speak, you can be held to the agreement that you've reached during the mediation process. And these principles are really often covered in the agreement to mediate, which all parties sign up for, and which we would encourage you to ensure that your clients and you sign up for before you go into Rule 41A Mediation 2. And it's part of the rules, and there are examples of them, certainly on our website and many other places. What the process looks like, I'm going to, I think we probably need to move on a little. What the process looks like, the mediation process, just if you can visualize it, is it's a negotiation process, so to speak. So this is really a negotiation process in the middle here, where parties are on opposite sides of the table and they pull in a neutral mediator to assist them to negotiate a dispute. And the mediator, the skills or the process that the mediator adopts is to work with the parties jointly, so to keep them around a table if necessary, but also to meet with them separately. So we're trying to illustrate that there. So as the mediator, you move between the parties. You have a principle of confidentiality when you're with them jointly, but also when you're with them separately, you're able to really interrogate aspects of their case, understand what's driving them, have conversations with them about the risks that they may face. But all that information remains confidential until you've asked for the permission and been granted the permission to start building a settlement between the rooms, and therefore firstly share certain information and eventually, share offers and a way towards a settlement. So that gives you a bit of a sense of what it looks like.
And as a practitioner trained primarily in litigation, when you're in one of those side meetings and the mediator comes to you and says, try to push your clients to really accept what's at the heart of this dispute, what's really driving it. There can be a tendency as an advocate to think, well, the mediator is a bit like a judge. Why is she asking me this question? How can I persuade her? And you find yourself suspending that entire part of your brain because you realize this person is genuinely curious about the dispute and wanting to explore it sincerely, which is quite different from the drama that unfolds in the courtroom.
Right. I haven't been following the chat and if there are any questions, but again, we'll definitely have an opportunity for these at the end, I hope. Good, so that just gives you a real sense of what the mediation process looks like. And of course, that's a very simplified version, but it does illustrate how you move between the parties and also work with them jointly. The next question, of course, is why it works, and it really does work. If you look at the statistics, about 75% of mediations do settle, and that varies from country to country. But I've actually never seen stats that are below 75% on settlement rates. And if they don't settle in the process, they usually certainly unlock things to a point where often they settle later on, either with the assistance of the mediator again, or because the parties are able to negotiate a settlement going forward. But the reason why they settle really is because they do create a safe space where a mediator can help the parties really explore their options, and explore their options given new information that they may have received, but also explore their options with the benefit of someone asking some difficult questions, and getting them to really think about the risks of the matter that they're dealing with. The other reason I think mediation often works is because it really does focus on having a conversation, and it moves away from putting people on the spot, for making people justify certain legal principles or legal approaches, justify why they did certain things. That becomes irrelevant when we're speaking about, well, how do we take this forward? How are we going to make this work for you going forward? So the arrow there really just gives you a bit of a sense what we're going to be exploring as mediators during these processes. Is we speak about what's happened. We definitely speak about what happened in the past, what the facts are, what the law says, what rights you have given the facts that you're purporting to, what the evidence is, so to speak. So there's some understanding of that, of what's happened in the past, but then moving the conversation very much to what's happening now. What are the commercial or financial realities that you're currently facing because of this dispute? What is the personal and emotional impact that the disputes had on you and your life and your business, and the way forward? So spending some time understanding that, and then starting to look for a way forward, starting to look for opportunities going forward, how to retain certain value going forward, how to create additional value going forward, given the dispute that you're in, and starting to see a future without this conflict or this dispute. And that's often a really useful process to put parties through. And because there's an approach on all of these, you also then are able to encourage a holistic view of the dispute, where, in the past, people may have been really focused on their specific right and feeling aggrieved because their rights have been impacted. It could be really useful. I think I saw someone say, what about insolvency matters? We have a mediator on our panel, actually, who works in that space, in the insolvency space, and is very effective in helping parties reach agreements around those issues too. So, people often ask, well, what disputes can be mediated? And certainly in our experience, any disputes can be mediated. You just have to ask whether the dispute is ripe and ready for that intervention, that mediation intervention. And under Rule 41A, you may not have a choice, but certainly you may have an opportunity to really unpack that dispute with the other party. I mediated a Rule 41A case 2 weeks ago, 2 or 3 weeks ago, 3 weeks ago now. And it was the first time that the parties were in the same room for 4 years. So it really gave them the opportunity to to work on the matter for the first time in 4 years, and to speak to each other and to really give the other party a view of where they're coming from. So it's an extremely useful process if you can use it to the benefit of the parties.
I mean, it's probably worthwhile mentioning that this taking a holistic view of a dispute is, on the one hand, very satisfying for a practitioner, and on the other hand, it's something we very rarely get to do, because we often construct litigation with an intentionally narrow focus. So we're going to bring this part of the claim first, and then we're going to bring that part of the claim, and then we're going to consolidate the cases at a later stage because it's of strategic benefit to consolidate them only later, purposely looking at the dispute only through one particular lens or from one aspect, trying to pull one of the levers because we don't want the other levers pulled right now. And mediation shifts that paradigm of disputes, and there's a very different approach, and that can be challenging as a practitioner when you have to sort of realize that actually the parties are there to, as Marian said, imagine a future without this conflict, rather than to imagine a future where a judge has awarded them some aspect of damages that will partially but not completely satisfy them, and they may see the money in 5 years' time. So I mean, it reminds me very much of one of the first mediations I was asked to be an advocate, for one of the parties in the mediation in front of a very experienced mediator. And these were both, the corporate parties. There's some businessmen, and I think it's probably fair to say big egos on both sides. No one wanted to lose face. And, when I first looked at the papers, I thought this is a dispute about contractual performance, about interpretation of a clause of a contract, and failure to perform by the other side. As the mediation unfolded and the mediator explored the conflict with the parties, and because the legal representatives were, in a sense, they didn't obstruct that process. They allowed the parties to genuinely explore with the mediator, while safeguarding their rights and everything else. And it turned out at the end of the day, after one day, these parties averted 5 years of litigation over 20 million rand and managed to preserve an ongoing relationship that was of value to them, because it was a relationship between a financial institution and a service provider. They needed each other. And they realized that their entire dispute had nothing to do with their contract. It had to do with one person misreading a financial statement and not understanding it. But the space was safe enough that the person could acknowledge that they didn't understand the financial statement in a way that they didn't lose face, because the mediator was able to create that environment. So it's probably useful now. I don't know if I can't see your slides, but is to really get to that, is why does mediation work? And I mean, it's the essence of it is that litigation by its nature is often focused on the past. I mean, we plead facts, and we don't plead the future, we plead the past, right? What happened? This happened, and then that happened. Whereas the mediator is usually helping parties to understand that what is their present reality, to read their present reality and make decisions based on that. So this is where the real satisfaction of a mediation practice comes in, is because, as advocates, we often walk away from court, tapping ourselves on our backs or tapping our juniors on their backs, but really thinking to myself, deep down, yes, I won. Yes, my client won. But have I solved their real needs? Have I solved for their real problems? And if we're honest with ourselves, sometimes the answer to that question is not at all. Whereas mediation offers us as practitioners, whether we're acting as mediators, to try to create with the parties creative solutions that actually generate new value in the relationship. And if we're there as advocates for the parties, well, to really stand side by side with someone as they are creating new opportunities. So that can be on an emotional, psychological, and professional level deeply satisfying. So probably the question on your mind now is, well, I'd like to do this. don't I already know how to do it? I mean, I passed the bar exams, you know, so what else is needed?
Yeah, so I guess that's where I come in terms of just accreditation. And of course, I almost feel like I'm peddling snake oils at the moment, because absolutely that's what we're looking at having, at the end of the day, really a good application of Rule 41A. And you know, how does one measure that? I guess you measure that as to whether parties are using the rule and just using a tick box approach to the rule. So basically just saying, okay, well, now I've either filled in the forms to argue why no mediation mediation cannot work in this instance, or I've got a mediator and kind of pretended to go through the process with a mediator. And that the result of that will just be that the process doesn't have the benefits that it can have. It can have for parties, but it also can have for a system which is quite slow at the moment, and certainly doesn't necessarily give people, you know, the type of justice that they need and the time required. So we have a real interest as Conflict Dynamics to ensure that we can build a system that's credible around mediation, and that at the end of the day gives sustainable settlements. You know, that's really what mediation is all about. And the first step really towards that is about having good mediators, and thinking about what type of mediator is contracted in 41A disputes, rather than just like maybe passing it around to tick the box, so to speak. So the first decision you really need to make for yourself, I guess, if you're interested in mediating, or certainly for your parties, if you're referring a matter to mediation, is who's the best mediator for this matter. So think about, you know, whether this is a civil or commercial matter, whether it's a family divorce matter, whether it's a labor management matter, and find a mediator who can really assist you in a specific area. Okay. What we certainly, what we offer in terms of accreditation is we offer what I would consider a very good generic mediator training program, which then you may need to refine your practice more by specializing in certain areas, but look for a mediation skills course, which is which gives you a very, very solid base. In the South African context, you also really need to look for a DISAC accredited training provider or a DISAC accredited mediator if you're choosing a mediator. So be aware of that. DISAC is the only, at the moment, body that sets standards for mediators and for mediator training. So it's important to just have that in mind, of course, especially if you're thinking of training as a mediator. What you can expect, and we've kind of outlined it there, any DISAC accredited mediator training provider will insist that you do at least 40 hours of training, that the training involves some coaching and certainly an assessment aspect to make sure that you actually are on top of the competencies. Look at being trained by an organization that has experience, that ensures that you're being trained by people who really understand the skills and the practice of mediation. Make sure that it's competency-based, so that when you leave that training, you can actually go and sit in a mediator's seat if you're found to be competent. and certainly some thinking before the training and some thinking and writing up after the training, I think is critical to the to the quality that you're going to get at the end of the day. Yeah, make sure that you can be accredited through the training, and certainly the training we offer gives you an opportunity for international benchmarking as well. So we have a relationship with the Centre for Dispute Resolution in the UK, and we are a International Mediation Institute accredited provider. So that gives you that international benchmarking. That is very, which is valuable here, but it's also, if you're looking at any cross-border disputes or looking at applying your craft elsewhere, it's really important that you have those international accreditations. And all the above really speaks to our Mediator training program at Conflict Dynamics, and I'm sure to others, but I'm here to speak about ours. And then additionally, Salim indicated earlier that we also have a training course where we assist people who are representing parties in mediations in doing that effectively. So we have a one-day training course on mediation advocacy, which is a lot quicker than the 5 or 6 days of Mediator training that we offer, and which really sets you up to understand the mediation process and understand how you can make the most of it for your client. So those are the two training courses I can speak to. And then I think, Salim, over to you to speak about how to actually develop a practice, which you started with. So it's a good way to end, I guess.
And I know that Ronel's hand has been up for a while, so I'll just cover this very briefly, just only because there may be people in the room who are newer practitioners who are thinking, well, once I've got this training, what does it actually look like to practice as a mediator? And there's just some practical tips and tricks here. Most advocates, because we're independent practitioners, we're already used to being quite entrepreneurial. I think the polite world is you have to hustle. And so we know quite a bit about hustling. And having that entrepreneurial attitude will help you to build a mediation practice, because most attorneys don't even know that it's an option. If you just mention to them, I'm a qualified mediator, I just finished this great course, this is what I learned, you'll find that they'll start briefing you in mediations, and before you know it, you discover that your attorney is also a qualified mediator and actually really would like to broaden her mediation practice as well. So it's a kind of a win-win. A business case, a marketing plan, all of that is important, including the use of social media judiciously. Where some of us at the bar are I think, rightly cautious about how we advertise ourselves on social media. And some of us find the advertising of our colleagues a bit distasteful, actually. So, the way in which you do it, well, there are ways to market yourself as a mediator that are entirely professional, entirely ethical, don't amount to puffery and touting. You can get yourself onto a panel, and there you feel the effect of a kind of a peer community, right? Where people are all striving to uphold a set of common standards, like your bar association. Being on a panel of mediators has very much the same dynamics, of a community of practice. And engaging in continuing professional development with that group is also important. But in my experience, at least, mediation can very quickly become a regular source of briefs, quite frankly, a very valuable part of practice. Not only, I don't mean financially valuable, but professionally valuable. It's probably worthwhile noting as well that the fees one would charge for mediation compared to the fees one charges at the bar may be slightly different, and to be prepared for that. So that's it from me. Marion, I'm not sure if there's anything else. Are we ready to take about 10 minutes of questions and discussion?
Wow. It seems to me that the adversarial environment in which we operate dictates against a more solution-orientated approach. the example you mentioned about the parties that through mediation were enabled to continue their commercial relationship. That's not something which is part of our day-to-day briefs. And I see this, our colleague Kaji, he said that we at the JSC have been engaging with the JP and the DJP regarding Rule 41A. The JP is concerned that there has been a very slow uptake of the rule given its voluntary nature. And apparently the SALRC is looking at amending the rule to make it compulsory. DJP Sutherland has asked questions, and this is where Kaji hit it on the nose. What type of matters can be effectively mediated? He believes there's a place for it in family law matters, rental disputes, etc. But there are reservations expressed about its utility in medical negligence and RAF matters. I did my mediation training through UCT and a similar organization during lockdown. In the role play sessions, there was a medical negligence matter, and the dignity violation, the acknowledgement of what created the conflict was amazing for me to see. I can understand that you can mediate something like a divorce. Many of our colleagues think because they settle a divorce, they can be mediators. We know that's not the case at all. But how do we sell mediation to the judiciary in matters that are not typically seen as matters capable of mediation?
I mean, I could try and respond to that, Ronel, just by saying that I've been involved in a number of medical malpractice mediations and have successfully mediated them. So you know, I'm guessing that you trained with mediation in motion because they have a very strong practice on that, and it certainly is possible. And in the UK specifically, it's again, you know, cases have to go to mediation before medical malpractice cases have to go to mediation before they go to court, and they settle there. I mean, I see there's also a very strong push from the South African Medical Legal Association to build a group of competent and experienced mediators in that field. So again, it's very difficult to exclude any case from trying to be mediated. And I mean, I sound like that. You know, once you really start speaking to people about what their interests are and what their priorities are and what they want to see the future like, it's possible to reach settlement.
Excellent. I see our colleague Kaji has got his hand up. Let's hear you.
Okay, just sorry, Marian, just a follow up on what I've already posted. I think the concern raised by the DJP, for instance, there's a car accident. Driver A says robot was green for me. Driver B says robot was green for me. I mean, how do you mediate that? I think that was one example he gave. Or else in a medical negligence case, I mean, if there's an acknowledgement or merits have been settled, I mean, I think it's one thing. But for instance, if the doctor says I did nothing wrong, and the patient is now presenting with all these problems, you see, I mean, those are the type of things I think the DJP has raised. And also, I think there were previous attempts that he has also mentioned, because remember, he's got many years' experience, even as counsel, where previous attempts have apparently floundered as far as mediation go. It is how to make it an attractive proposition and sell it to the litigating public as a whole. Well, I know in your courses you do mention that, you know, when you mediating, you have to show, well, the parties have to come to a realization what's the best possible outcome from litigation, what's the worst possible outcome, what's a realistic outcome. I mean, those things all have to be explored. But even then, I think it appears that the DJP is of the view that certain matters are far more amenable, I think, to mediation than others. I mean, I think I'll just leave it at that.
Absolutely. Again, I'm not sure, Kaji, whether one can kind of say these are and these are not. You know, it's a case-by-case matter in which you analyze the dispute, you analyze the process, and you get a sense of, okay, well, this one really, we need a precedent on this, or we've tried to mediate this before, or we've, you know, and you really analyze the case before you decide which dispute resolution kind of route it goes. I don't know if that helps you, but certainly that.
These are just the questions raised by the DJP, and then also the DJP. I think he wants some stats on how the Samla mediation pilot project went, both in RAF and in medical negligence. And I think you guys can also provide some of those stats. I mean, so you can give him a feel of how it went. And I think if you can just engage with the DJP on that. Because I think he's quite eager to know how those projects have panned out.
Thanks for the heads up. Absolutely, we'll do that. Thank you, Kaji.
Kaji, I must say, and that's what makes this platform that you know, the SA Bar Association creates, especially the initiative to create the opportunity, is that with your experience, it would add a tremendous amount of value to engage collectively. Kaji, I know, is involved with the judiciary directly on an advisory level, and he's been involved in some of our previous discussions. And there's a straight line to facilitate, I think, importantly, knowledge about what can be mediated. As we sit here, whether we've got mediation qualifications or not, as I said at the outset, I cannot imagine mediating, for example, an insolvency matter. How do you walk away from an economic money mentality? But you've given an excellent example already. I'm mandated to keep my eye on the clock. Might I propose that if any one of our delegates that are attending the platform, please email your further inquiries. I've prepared some questions of, and it's a soft spot for me, but how would our young colleagues as counsel, how do you activate that part of your practice? Those are the kind of things that I would like to get going on this kind of platform. So if I might propose that the attendees that have further questions, of either for your own associations or from a personal perspective, the same platform on which you received the link for this afternoon discussion, please post your questions. We'll make sure that it gets to Marian and Salim. And Kaji, don't disappear. Please assist in facilitating the engagement between Marian and Salim and our judiciary. And let's get this ball rolling. It's so exciting. It's incredibly exciting. I'm almost tempted to carry on, but of course we have all our own responsibilities. You guys are so passionate about the subject. You're so knowledgeable about it, and it's like a little window that opened. Thank you so much from all of us across the board outside of SA Bar. And I have a feeling we're going to be bumping into each other sooner rather than later. Thank you for your time and the level at which you shared in the short space of time some insight in what seems to be the future of all things not litigation. Thank you very much, guys. Thank you so much.
Thank you, Renal. Thanks for that.
Thank you very much for the opportunity.
Thank you, guys. Have a lovely afternoon.